Welcome to the courtroom of the Supreme Court for the launch of the 2020 annual report of the court. I'm joined here in the courtroom physically by my colleague Ms Justice Marie Baker, who will shortly speak on the outreach and international engagement of the court in 2020, and also by the Registrar of the Court, Mr John Mahon, who will give some headline facts and figures from the report, which demonstrates our work over the last year. And I'm also happy to be joined, if remotely, by the other members of the court who appear on a screen to the right. And I will shortly have to deal with how we have managed in the extraordinary year of 2020 with the pandemic. But even at this early stage, I would like to draw attention to the fact that a screen such as this is the way in which the public are able to see what's happening in the Supreme Court when we hear cases remotely. Any member of the public who can come to the courtroom gets as good a view about what's happening in a remote hearing as anyone else who's participating in that hearing. What we are launching today is the third annual report on the work of the Supreme Court. The previous two editions, for 2018 and 2019, were in fact launched during sittings of the court outside Dublin. That has become an almost annual tradition for the court at this stage. And the report last year was launched during the court's visit to the southeast in Waterford and Kilkenny, which followed from previous visits to Cork, Limerick and Galway. And in passing, I should say that I'm still hopeful that, subject to conditions, the court will be able to, at some stage during this year, have a sitting in the northwest, in Letterkenny and in Castlebar. That had been planned, and as I say, hopefully we will be able to deal with that. But the launch in Kilkenny took place in February of this year, when we were just beginning to learn and focus on the coming pandemic. And clearly the effect of the pandemic on all of us over the last year has not spared the Supreme Court. And a lot of what is reported in our annual report reflects the difficulties which the court has faced, the challenges which it has faced, but perhaps also some of the opportunities which have become available because of handling the pandemic. It's worth reflecting that it was on the 12th of March last that the Supreme Court sat in this courtroom for the last time to hear a physical appeal. That was the day on which then Taoiseach Leo Varadkar spoke from the steps of Blair House in Washington and introduced the first elements of restrictions, which were to grow some 2 weeks later into the first full lockdown. And the court was meeting outside this courtroom in our conference room just to the left of me here to discuss the case which we were about to hear, when we listened on the radio to what was being said from Washington. And it became immediately clear that the way in which the court would have to work over the following period was going to have to change radically. Perhaps we didn't at that stage realise for just how long those changes were going to last, but nonetheless it was clear that they would last for some time. It became absolutely clear to us in very early course that the best course of action was to attempt to set up the capability of having remote hearings so that both the parties who need to be present, their lawyers, and indeed the court itself would not be exposed to any unnecessary risk of contracting COVID. And I think it is fair to say that we did get remote hearings up and running in a very short period of time. That was the 12th of March. By early April, we were in a position to run some trial moot hearings to see how things worked. We were able to tweak the system a little. And by the end of April, only 5 or 6 weeks after that initial emergence of the problem as a real question that we had to address, we were able to conduct remote hearings in the court. And it is a fact that the only single physical hearing that the court has conducted since the 12th of March took place in the Great Hall of King's Inns, which was big enough to be able to accommodate a court of 7 judges and a significant number of participants and parties, and indeed some members of the public who were interested in what was, I think, a very important case concerning the government's climate change programme. So apart from that hearing, every hearing which has been conducted by the court in the last year has been conducted through a remote platform. And I want to say a little about what we've learned from that, the challenges that we faced in attempting to put that in place, and the effects that that may have for the future. We have been able to conduct a small number of ceremonies physically in the court, sometimes with persons present, sometimes with persons remotely. But we haven't been able, because of the confines of this courtroom, to conduct full hearings. As the Registrar John Mahan will explain, the number of cases coming to the court have been somewhat reduced over the last year, partly, I think, because the courts from which we hear appeals, the High Court and the Court of Appeal, have themselves been operating under some restrictions, though I think that will in time feed itself through the system. But I think that lower number of cases has given us significant opportunities to introduce new procedures, and I would like to say something about those, and also what we have learnt from the experience. The first thing I think to comment is that it has led to the court being extremely up-to-date in its work. At present, if a case was given leave to appeal today, it's likely that that case would be the subject of a full appeal hearing probably in late June or early July. I don't think, except in exceptional cases of urgency, where we can impose very tight deadlines on the parties for filing their written submissions and submitting whatever documents and materials the court will need to have to hear the appeal, except in those urgent cases, I don't really think it could be done much quicker without putting undue and unfair pressure on the parties. So in terms of hearings, we are as up to date as I think we are ever going to be. In terms of judgments, we are, again, I think, more up to date than we have been in living memory. As of tomorrow, Thursday, there will only be 6 cases which have been heard in the Supreme Court with judgments reserved where the judgments have not been delivered. And the normal figure in that regard would often be in the high teens. So we have used the opportunity of a smaller throughput of cases to get as up to date as we've ever been, and hopefully we'll be able to retain that position as time goes on. We've also used the opportunity to introduce new procedures, some of which we had been planning for some time, but they became perhaps more urgent in the context of remote hearings and in the context of the pandemic. There is in the annual report, for those who are interested in more detail, an account of the progress of a typical appeal before the Supreme Court. But some of the new aspects of that system are ones I'd like briefly to comment on. We have now introduced a procedure where, after the parties have filed their written submissions and filed the materials necessary for the court to consider the case, a so-called statement of case is produced. That is an initial position by the court, not indicating any view on who should win and who should lose, but setting out our view of what the questions are. What's the background to the case? How has it come to be here? And what seem to us to be the issues? And that's sent to the parties for their comments. And if, for example, we haven't got everything straight from the papers, then our misperceptions can be corrected in advance of the hearing. Accompanying that can often be what's called a clarification request, where the court can ask the parties to give further detail about their position on issues that seem to the court to be important. And again, I think both of those measures have allowed much greater focus to arise in advance of the hearing and has tightened up the oral hearing before the court, because time isn't wasted anymore in dealing with clarifying matters or going into things that could easily have been dealt with in advance. I think in part that was necessary because of the limited interaction that's possible on a remote platform. The typical questioning that goes between the members of the court here on the bench and counsel in the front seats down there can be often very robust, but that level of constant interaction really doesn't work on a remote platform. And therefore there was a need, I think, to put in place that added clarity in advance so that remote hearings would work to their best advantage. But I think those procedures will remain part of our process in the future because they've turned out to be a very valuable addition to what we're doing. What have we learnt from remote hearings? I think we would all agree, though there might be some slight nuances of difference, that they provide an adequate hearing. The alternative was probably no hearings, so that was a non-runner. But I think most of us think that for the full hearing of an appeal before the Supreme Court, the remote hearing is not ideal. And I think the intent would be that we would go back, mainly at least, to full physical hearings in the traditional manner as soon as that becomes practically possible in accordance with whatever restrictions are in being for the time being. But in terms of case management and the build-up to the case prior to the full hearing, I think remote hearings will remain an important part of our process. Instead of lawyers having to travel to come into court for a perhaps 5, 10, 15-minute discussion with a judge about how the case needs to be got ready for hearing, that can be very easily done remotely and with much less burden both on the judge and on the parties. We've also dealt with more things on paper, and that's the last thing I'd like to comment on, because it has been the subject of some public debate. We don't deliver judgments in the courtroom anymore. They're delivered electronically to the parties. And instead, therefore, of an immediate debate with counsel about what form of court order may be necessary, what's to happen, the costs of the proceedings, there's now often an exchange of documentation after the hearing and a further written ruling by the court. And it's sometimes said that we should make much greater use of a written procedure. Some have even argued that the oral procedure is unnecessary. I have to say the experience we have gained in the last year, and I think the view which I'm about to express is one which my colleagues would share, would suggest that a written procedure is no substitute for the rigorous, robust debate that happens in a courtroom. But apart even from that, I don't think it would actually save time or cost. I have certainly found that more time is spent by judges in having to tease things out when they only have a written record. Something that could have been solved in 5 minutes of quick questioning of physical people in the courtroom can take an awful lot longer outside the courtroom. So those who, I think, have suggested that it would be possible for the court to dispense with a lot of oral hearings, I think are mistaken. It wouldn't give as good a result, and it wouldn't even achieve greater efficiency. It would actually add to the total amount of judge time that would be needed to bring matters to a conclusion. So I think that's a further lesson we've learned because we've now had a practical experience of it. It happens to confirm the view I would have had in advance, but sometimes experience shows that your initial view is wrong. But this is one case where I think our initial view has been proven correct. We need a robust debate in this courtroom to get the best result possible, to define the law as best we can. And I think that's something we will go back to as soon as it becomes safe. And there's much more detail in the annual report for those who are interested in delving into these matters in much greater detail. I hope that those of you who have an interest in the way in which the Supreme Court works and the way we have responded to the challenges of the pandemic will find at least some of the contents of the report interesting. And the final thing I would say it concerns that part of the report which hasn't changed at all. The report contains an account of the decisions which the court has made in the most important cases of the last year. And the interesting thing, I think, about it is that that bit of the report doesn't look any different than it did in other years. And I think that is something that we can rightly take some pride in, despite the challenges of the pandemic. We have been able to deliver the judgments of the court in the same way as we have always done. And that is, I think, to the credit of the staff who have helped us, the court service who have assisted in getting remote hearings up and running, and judges who have had to learn to do things in a way that we wouldn't have anticipated as being remotely possible even 15 months ago. Thank you very much.
I'm very pleased to introduce this third annual report covering a year which brought with it unparalleled challenges, necessitating significant changes in our daily work at a pace which I would suggest was also unparalleled. Over a very short period in April, as the Chief Justice has said, the Court moved to conduct its hearings by video conference, and the judges of the Court and the staff who support them developed the processes and procedures necessary to ensure that this move was effected in a just, efficient and safe way. It's a testament to all concerned that Supreme Court hearings were not delayed in any significant way during the year, and that a backlog of hearings did not develop. In fact, at year end, all scheduled appeals had had their hearing. The number of applications for leave to appeal filed did reduce significantly in 2020. There was in excess of a 30% reduction, but this was due to the overall reduction in court business during the pandemic. However, the time gained as a result has been put to good use, and the Court has been able to further reduce, to the extent possible, the waiting time for an appeal to get a hearing. Currently, litigants at final appellate level where leave to appeal has been granted can ordinarily expect a hearing within 14 weeks. This is a significant reduction. For the average appeal not requiring to be dealt with on an extremely urgent basis, this is probably the shortest that the period can be, allowing for the effective management and the logistics of the hearing itself. The reduction in applications for leave to appeal filed is likely to be short-lived, and I anticipate that the rate of increase in such applications experienced in the period 2014 to 2019 will resume later this year. Once again, I am grateful to the Chief Justice and to the other members of the Court for their continuing support and engagement with the Office throughout the year. The Court worked hard during the year to adopt new technologies that have allowed hearings to take place in a safe environment for litigants, practitioners and staff. There were significantly in excess of 100 such hearings during the year. The automation of virtually all business flows in the Office in support of the Court's remote hearings and the sharing of electronic documentation created significant challenges for the Office operations throughout the year. This happened in tandem with the necessity to observe physical distancing requirements and other government guidance. I'm glad to say that these challenges were overcome. I'm very grateful to Office staff for the manner in which they have responded to the changes necessary as a result of the pandemic, and for the fortitude which they have shown throughout what was a very difficult year. Members of staff had to pivot quickly in a changing environment, and I believe that this will serve us well for the future. Whether working from home or on site, they have responded positively at all times. We look forward, hopefully, and we will bring with us the best of what we have learned, and this will enable us to build on the continuing improvement in the services that we deliver to the Court, to practitioners and to the public. Thank you.
One aspect of the role of the Court, which is perhaps less obvious, is the role that I want to very briefly mention, and which has some detail in the report, and it's what we call our outreach programme. This is a number of things. It's our engagement, whether collectively as a Court or individually as judges, with universities, with schools, with the legal profession, with wider society, and also our international engagements. We've been busy this year. We've all become quite good at using various Zoom-like platforms. We've attended and given papers at lectures and seminars, and we've continued with our school programme. I'll come back to that in a moment. These particular engagements, which the court has, as the Chief Justice said, now established as a tradition, if you can establish a tradition in that length of time, they have as their value the values of accessibility of the court, openness, but probably more importantly, a desire that the wider community would have some knowledge of the role of the court, some knowledge of the place the court plays in our democratic structure, and some knowledge of the personalities, the persons in the court, and how the court works. We do ourselves learn quite a lot from these engagements. We learn from the robust engagements in universities. We learn from the courageous questions that are often asked by particular school students at the co-raw and school visits that we make, whether they be physical visits or online visits. And we have learned a lot from our engagement with wider society. This year has been very different from the year we expected. We did manage to make a very good visit to Waterford and Kilkenny at the end of February, before anyone knew the pandemic was coming. And we managed to have a full engagement there with society, with the universities and colleges and with schools. We sat in both courthouses in Waterford and Kilkenny. We heard cases, we delivered judgments. We visited schools and colleges, and we individually gave papers to various groups in the two cities. Waterford had a particular resonance this year. It's the birthplace of John Hearne, often described as the parent or the father, I think, of the Constitution. We visited the permanent exhibition in the City Hall, and we saw the first enrolled text of the 1937 Constitution, which was a particularly nice thing to see. In fact, an extremely good exhibition. Our colleague Donal O'Donnell gave an important keynote speech on the Constitution, and that was very well received and very, very well attended in Waterford. We visited schools. That was particularly interesting because it was my very first visit to a school, a physical visit to a school as a judge. And the questions we were asked were most engaging, sometimes very difficult. Sometimes we had to admit we didn't know the answers. We didn't have any books with us, but very, very interesting. And it was also interesting to see the number of students who said that they might like to become lawyers, some of whom even said that they might even like to become judges. This was very good, very interesting to see, and interesting to see the way in which the court was in fact visible in society. The other aspect of our outreach programme is the international programme. That, in fact, this year has involved nearly all online Zoom-type meetings. But the Chief Justice did get to give in person the keynote speech at the opening of the judicial year of the European Court of Human Rights. And that was a very well-received speech, which was broadcast widely through the court's own website. We did manage to have a very enjoyable, although somewhat quieter, bilateral meeting with the senior members of the UK judiciary in early December. It was quieter because we were all speaking the same concerns regarding how we were to engage with the administration of justice in public in the pandemic. And it was interesting to see the extent to which we had the exact same problems, to see the extent to which the same kind of cases were arising and the same practical problems as to how we were to do our jobs, and how we were to successfully engage with practitioners and with litigants. There were a number of other visits, virtual visits, I should say, by members of the court to various seminars and lectures. We gave talks. We were present at seminars. This is a very different way of working. Personally, I find, while I have no difficulty in particular with using the Zoom-type platforms, I find the lack of the opportunity of talking to colleagues from international courts, colleagues in particular who have quite a different way of working. That's missing. The chat over coffee about how a court deals, perhaps say with data questions, or how privacy questions are evolving in the thinking of the various courts. These are missing from the online platforms because, unlike Irish people, I have found personally that the European judges don't chat before the seminar starts. They all wait quietly until the seminar has started, and while questions get asked, the sessions are quite different from the chats you would have over a coffee during a break. So the year has been different, it's been challenging, but we have kept going. We have continued to do our CORA visits to schools virtually. They were always done virtually. Some of them are done in Irish if the school is a Gaeltacht, or in a Gaeltacht, or if it's a Gaelscoil. And some of them are done in English. They've been very engaging. I think the students have enjoyed it, and certainly the judges have. So I commend to you the section of the report which deals with those perhaps less obvious roles that we do, and ones from which we personally gain a lot.
Can we finish by saying that I hope that this short presentation will have encouraged people to perhaps read more deeply into the work of the Supreme Court as set out in this year's annual report, and indeed for those who are even greater suckers for punishment, the previous reports on which it builds. But the last thing I'd like to say is that I suspect all of us would hope that in the not too far distant future, the situation in the country will have improved sufficiently that this courtroom will once again reverberate to the robust debate between members of the court sitting here on the bench and counsel making argument for the court. As I said before, that's the best way to get the best result to cases, and we hope to be back doing that as soon as it's safe to do so.